President Biden has.
If we're going to talk, we may as well go ahead and record.
Okay. President Biden has started off very strong on the issue and bringing the level of urgency that is required with his executive order 1408, where he says, look, we're facing a climate change crisis. We cannot deny it. The science and the consensus in the science community is unanimous on that issue. And we must take steps. Firstly, develop cleaner forms of energy, reduce dependence on fossil fuel. And in cases where, of course, you know, there have been pollution and things of that nature, we must take remedial steps. He also went further to say that, look, it needs to be at a global level. So in his meetings with leaders of other nations, he's tried to emphasize that fact, not just talking, but also things like cutting down, increasing the reduction of emissions in nations. And that ties in to the Paris Agreement, where, you know, most of the nations of the world have signed up to it. But what tends to happen is that people sign up, but do they follow through? But he has said, look, we would not be providing funding for certain fossil fuel projects. In Europe, the EU and the UK have also toed that line that they would not be providing funding, for example, for natural gas. It would require a global effort, really, to deal with the climate change issue. And so President Biden is taking the proper lead in that respect, because without that, it would be a bit of a patchy effort, because you are reducing efforts in Germany, but the efforts are not reflected in Nigeria or in China or in Russia, where they are going full steam ahead. So it will require a global effort. And that, I think, in my judgment, is what President Biden has set out to do. And that is commendable. So it will require a global effort. But global efforts, firstly, reduce your emissions, and hand in hand, develop new and renewable sources of our energy, like wind. And New York has taken some steps in that regard too, commissioning some huge wind turbine projects off the coast of New York with Equinor and BP. So those are the kind of things that will need to be done. As to whether the developing nations, petro-states like Nigeria, Angola, new petro-state of Guyana, whether they'll be able to do that immediately is yet to be seen. But there's certainly something they can do if we look at some of their national determined contributions they have made to the Paris Agreement.
Do you think the new petro-states will be sensitive to the need for addressing the catastrophe that is climate change?
If it were 20 years ago, they probably would be more resistant. But 20 years after, in cases like Nigeria, Angola, we can clearly see that there are substantial difficulties from an environmental point of view. So in many cases, the new petro-states, like they have a precedent for what not to do. So that's the best way I can put it. In as much as they'll be anxious to, you know, get their economy in shape and the rest of it, but they must also be responsible and learn the lessons that those who have gone before have had to put forward. Yes, that's what I think it can be done with.
Let me just say hello to Valley. Welcome, Valley. Glad you're here. And it is a couple minutes after. I think, we could go ahead and start your presentation. And Teraine, I really do think that we need to figure out, I don't right off know how to get this onto our webpage or put copies of it off, but I hope that we can publicize this a little further than we normally do, because I think we've gotten good feedback from people who, I hope they're not having a hard time getting onto the call, because I think that a number of people have expressed a lot of interest in what you're going to say. So I think they're going to want to see it, even if they're not here at the moment.
That's all right.
So
well, Art was wanting to be on, and he sent it to his list. So I imagine a lot of this. I'm wondering, you made it easier to get it on this time. I mean, the link was really available right on the front of your webpage. So I don't know. People are having.
And I sent out too. Art sent out. I sent out several times.
Yeah.
Yeah, but I don't think we want to. And of course, they may find their way on as the session goes along. But I don't think we want to wait too much longer, though. Do you want to go ahead and start, Shelley, and give us an official opening?
Well, first, hearty welcome to Teraine Okpoko. We were so pleased when you very unexpectedly joined us last week. We said, who is this man? And we found out, we want to hear what he has to say. Valley, I don't believe I've met you before. Maybe, I don't know if you were on last month when we were talking about Shalonda Baker, but Teraine said that he could talk about the suit against Shell at the Hague he's going to talk about now. And I'm hoping, Teraine, you will just introduce yourself, tell us a little bit about yourself, give a little background on yourself, and also your connection with this suit.
Thank you. And thank you to the Omni Center for this opportunity. Of course, my name is Teraine Okpoko. I'm a New York attorney practicing in the state of New York, but I also have a practice license in Nigeria. And I have also been engaged in practice, although presently retired, but in the UK also as a solicitor. In terms of the nature of the work I do, it's litigation, more specifically, litigation relating to environmental damage caused by fossil fuel operations. And then I also undertake assisting various groups with campaigning, climate justice campaign and environmental justice campaign issues. And not just in New York, but also in the sub-Saharan region in West Africa. I do that. And then in Europe also, what I tend to do, it's in relation to transactional matters for solar energy and wind energy. So essentially, that's the work I've been doing, and I've been doing this work since 1991, really. So that's in a nutshell what I do and how I do. Thank you.
Well, thousands of questions already, but I'll just let you get into your presentation about the Dutch Shell, which you're here to talk about.
Okay, thank you. Today, if I may share my screen. Okay. Just a second, please. Can you see?
Yes.
Okay. Good evening and welcome to all our viewers. Today's talk, I intend for the purposes of this session to speak on the case of Milieaudefensie against Royal Dutch Shell. In this presentation, I would give a summary and an analysis of the case, its effect on global climate change litigation, and the corporate policies of oil companies. To gain an understanding of how climate change occurs, because the case really has to do with emissions by fossil fuel companies and how it affects climate change. For the purposes of those who have not been involved or are newly involved in global climate change issues, I would just quickly refer to a brief definition or a brief illustration of what happens when harmful emissions from fossil fuel companies are emitted into the atmosphere. It's a scientific illustration, but in layman's terms where we can understand it. And if you permit, I will just describe it as follows. Mankind has been using energy primarily produced by burning fossil fuel. Your car, burning coal, burning fuel, burning oil, burning gas on a massive scale since the Industrial Revolution. And in this process, carbon dioxide, which is a greenhouse gas, is the chemical formula is CO2, is what is released into the atmosphere. And it lingers there, and it's been there for over 100 years. Some of it, of course, is reabsorbed into the atmosphere, through our ecosystem, the forests and the ocean. But that natural absorbing effect is being limited because, of course, of the deforestation. But again, what makes it peculiar at the present time is that because of the loss of forests and the oceans, the gas released, the CO2 released into the atmosphere is no longer absorbed by these natural absorbing forces. So what happens is that when it is released, it hangs in there and traps and makes the earth hotter. And that's what affects the climate system of the world. And because of that, it brings about global warming and brings about adverse weather conditions. We would look at, of course, what has happened just over 2 weeks ago or less in Germany and in Belgium. And that is what we call, or we refer to, or is referred to by climate scientists who study these weather patterns and emissions as global warming or climate change effects of global warming. So essentially, that is the science of what this case is about. Shell's emissions of carbon dioxide from its mining operations and its business associations, and its effects in terms of global warming and the adverse climate change that brings about. So firstly, who is Milieaudefensie? Milieaudefensie and 6 others were the plaintiffs or the claimants in this case. They are, as you will know, they are environmental activists or climate change activist organizations committed to stopping the dangerous climate change and taking steps to ensure that companies involved in fossil fuel operations reduce their carbon emissions or cease altogether and transfer their energy to more renewable and cleaner forms like wind and air. So that's who Milieaudefensie is. And Milieaudefensie really means friends of the earth in Dutch. Then as for the defendants, it's Shell, Royal Dutch Shell. We know who they are. But from the legal point of view, Royal Dutch Shell is a company that was incorporated in the UK, more specifically England and Wales. And it's located, or it carries out its operations from its headquarters in the Netherlands, not in the UK, interestingly. It's the Royal Dutch Shell, which I will subsequently refer to as RDS or Shell. It's the holding company for the Shell Group. The Shell Group is made up of over 1,100 subsidiaries. And so it transacts its business through those subsidiaries. And those subsidiaries are present in 160 countries of the world. So that is the magnitude or the scope of Shell's reach that the court had to consider when looking at its emissions level and what obligation it would want to impose on Shell. The next point we would look at now is what was Milieaudefensie's claim against Shell? Why did they take Shell to court, bring Shell before the Dutch District Court? There were a number of claims that Milieaudefensie had made in bringing the case before the Dutch court. But the specific one, not all of them were granted by the court, but the specific one that the court granted, and the court only granted one of the 3 to 4 claims that, or reliefs that Milieaudefensie was seeking. And it was to this effect. This is the one of the claims that Milieaudefensie had put in. It was like this: to order Shell, both directly and through the companies and legal entities it commonly includes in its consolidated annual accounts, essentially that means the subsidiaries, and with whom it jointly forms the Shell Group, to limit or cause to be limited the aggregate annual volume of all CO2 emissions into the atmosphere due to the business operations and sold energy products of the Shell Group to such an extent that this volume at year-end 2030 will have reduced by at least 45% or net 45% relative to 2019. Essentially, what this is saying is what Milieaudefensie wants is we want the court to tell Shell to reduce its global emissions by 45% before or by 2030. Not just emissions that it does on its own operations, but emissions that arise from third parties it's dealing with. That's its customers to whom it sells, oil and gas products, and parties from whom Shell receives oil and gas products, electricity, and things it uses for its operations. So essentially, that was the claim that the court granted. And what did Milieaudefensie do in terms of pursuing its claim? That's on what basis is it saying that Shell must be compelled to reduce its obligations or to reduce its emissions? Well, on that point, Milieaudefensie were, I would say, they were quite prudent and astute in their arguments. What they indicate is that, look, under our Dutch law, we have this principle of unwritten law of care, standard of care. It's called unwritten standard of care in the Dutch law, which is under the Dutch code, civil code. And what that principle says, which is similar to in our own common law system, is similar to when you have a negligence case, and the court says, okay, you have certain duties that the court recognizes. You mustn't drive your car in the wrong direction on the road. That's a duty that the court recognizes. If you do, you have broken that duty, and then you have to pay the consequences of any damages. So it's something similar, but not the same. It's something similar like that, that the Dutch court employed. Theirs is called the unwritten standard of care. And what the court did was that the court looked at the law and said, these emissions Shell is doing on a global scale, they are quite substantial. How do we get Shell to be held responsible? Firstly, to say, yes, Shell has a legally recognized obligation not to make those levels of emissions. Secondly, what duty are we going to impose on Shell to ensure that it stops making those emissions? What the court did, which was novel, it had not really been applied in Dutch law, or indeed in the law as we know it, either in the Western law, in the Western world, or elsewhere, either in this common law legal system, which is operational in the US and the UK, or under the civil law. It's never been done before. But what they did, they said, firstly, which is what is on the slide, they said, firstly, we have to make a finding that Shell owes that legal obligation not to emit dangerous greenhouse gases of the level which it was doing. How did they come to this? The court looked at Articles 2 and 8, which is of the European Charter on Human Rights. Article 2 talks about the right to life. Article 8 talks about the right to private life and the right to family life. Under those two articles, the court said, look, it is unanimous based on the UN treaties, like the UN guiding principles, and also one other finding that was made by the UN Committee on Human Rights. The court said, look, the right to life and the right to private family life are critical for the existence of human beings on Earth, but specifically for Dutch citizens, that these are crucial rights. So if a party is doing anything that would impact or diminish those rights, then that party must be placed under an obligation to ensure that it does not do things that diminishes those two rights. That's right to life and right to private family life. Then the court went a second step further and said, emissions that's relying on the science of climate change science, the court went further to say, look, it is of, there's substantial consensus, and it referred to many of the UN documents that have been produced in respect of climate change, the Intergovernmental Panel on Climate Change, that's the IPCC. It referred to it, and that's a collection of scientific data, and an expression of what the consensus in those data. And it says, look, it's not unknown, but rather it's a matter of common climate science knowledge that greenhouse gases, specifically CO2, which is carbon dioxide, which arises from burning fossil fuel, that it harms the climate. It has an adverse effect on the climate because it's trapped and results in global warming, which has a greenhouse effect. And the result of that global warming is that we now have adverse weathers. We have threat to the health of people. The air is less pure. Water sources are polluted. You have the melting caps in the Arctic region, which now leads to higher flooding from rising oceans. It also leads to subsidence, or should I say, threat of various portions of land, in this case, in Netherlands, being submerged because of rising sea levels. So that was the climate science the court had at its disposal. Then the court went further to say, look, knowing that this is the effect, it's not disputed. Shell in itself, in its argument, did not dispute that that was the result of climate change, that it has those effects. Having found that that is the case, then the court said, okay, good, you accept that. Well, in that case, you will have an obligation to ensure that you don't infringe on human rights of the citizens, namely their right to life and their right to private and family life. That being the case, and we know that your emissions has that trigger effect, you have to bring down the level of emissions, because the lives of the Dutch citizens and their well-being is far more important than your commercial concerns, as profitable as they may be. So that was a landmark decision for the first time, linking human rights, that's namely the right to life and the right to family life, linking it to the consequences of unregulated emissions of greenhouse gases. That's how the court was able to find that Shell, or RDS as we say, has an obligation. It has an obligation because what it's doing impacts the life of people, or that affects global warming, and global warming affects climates, and climate affects the life of our people and their health and our environment. So we cannot allow you to proceed in an unregulated manner. This was how the court was able to tie Shell in terms of responsibility. Shell, of course, not wanting to be seen to, should I say, surrender, did put in some arguments, namely, it said, look, these cases are not suitable. These cases are not suitable for court resolution. It's a matter for politics, that means the politicians, the legislature, and the executive are the right arms of government to deal with the case. It's not a case that should be brought to court. The court has no power to deal with political issues. And then it says also, look, everybody's doing their emissions. That's all other fossil fuel companies. We can't be held responsible solely for harmful emissions. Well, the court sympathized with them, but made it clear that, look, when it comes to determining if Shell has a legal obligation to reduce emissions, if that is the question that is being put across by Milieaudefensie, and that was the question, then the court has the eminent privilege, so to say, to deal with that issue and deal with it effectively. To pronounce upon whether there's a legal obligation or not is a matter for the court, not a matter for the legislature or any other arm of government. So that was how the court was able to come online and deal with that issue. Then in the court's application of this new duty on putting new obligation on Shell, the court tried to define the scope. How is Shell going to, or what is required of Shell in terms of the scope? Remember, this is a company that has operations all over the globe, 160 nations. It has 1,100 subsidiaries, over 1,100 subsidiaries. How? What do we want them to do? The court looked carefully at some of the reports that Shell had tendered, just their normal reports to their shareholders, reports to their investors, normal standard reporting requirements that for compliance purposes that Shell had filed over time using a specific format. And it devised a scope, the court devised a scope to determine what the extent of Shell's obligation should be. This is referred to as Scope 1. Scope 1 deals with those emissions that Shell does, or those harmful CO2s or carbon emissions that comes about as a result of Shell's direct mining activities. So, for example, Shell's mining leases, let's say in Brazil or Nigeria or Angola, any emissions coming from that run by Shell, then that falls within Scope 1. Scope 2 deals with emissions that is not necessarily Shell's emissions as such, because it makes the emissions using products or facilities it has obtained from third parties. So for example, in carrying out its mining activities in, let's say, Arizona, just say Arizona for the sake of illustration, if it buys electricity and fuel for pumping the drilling machine and securing the oil field, it buys them from, let's say, ABC Limited or ABC LLC. ABC LLC becomes Shell's supplier of those materials or those products that Shell uses in its operation. The judgment now speaks regarding emissions coming from that supply arrangements. I would come more specifically to what it says must be done for each of these categories. I'm only trying to describe the category first. And then the third kind of scope is when Shell sells its energy products to third parties who now use those products for their own purposes. For example, Shell, as we know, it sells oil and gas. That's its products. It can sell them to, let's say, company AB, who has, let's say, has a power plant, so as to, generate electricity. The pollution coming from that power plant owned by the third party to whom Shell supplies fuel is also caught by these judgments. So essentially, those are the three scopes. The first scope, emissions coming out of Shell's own operations. The second scope, Shell's emissions, all right, but emissions resulting from Shell using the energy products of its suppliers. And the third, customers of Shell that use Shell products for their own operations. What the court did, and in my judgment, I think one could hardly blame the court for looking upon it in this way. The court looked at the reports, that's the annual reports of Shell. It looked at the emissions obligations, and it also looked at many of the things, the policies Shell itself had endorsed over the years, its commitment in its statements to its investors and its shareholders to climate change. And it discovered that, look, Shell has a good amount of control over its customers, that's those it buys things from, sorry, suppliers, those it buys products from, or those that supply it with electricity. And it has good control over its customers, that's those to whom it sells products through. Then the court also found that, look, what we find, strange, so to say, is that whereas Shell has policies extolling the virtue of climate change and its effects, but its strategic investment policies are contradictory. It's saying we are ready to lower carbon emissions. At the same time, on the investment platform, it's saying we have to increase our oil fields production by 30% within the same time frame. So those were the things that the court found prudent to impose the nature of this obligation on Shell. So what in effect happened is that the court said, okay, you have endorsed many of these climate change issues in your various publicity materials. You are therefore aware of the danger of these harmful emissions. But in your investment strategy and in the caveat you have placed on some of your publicity materials, you have not demonstrated that you are seriously moving towards reducing your emissions. You have also endorsed the Paris Climate Agreement. Paris Climate Agreement, as you may be aware, is an agreement by various countries of the world where, under the auspices of the UN, of course, where they had agreed that, look, each nation, to combat climate change, global climate change, effects of dangerous global climate change, each country must put forward a plan for reducing emissions in its territory. And it set a yardstick. Say, look, to avoid this dangerous climate change, we must ensure that the heating is reduced, the emissions is reduced to 45% by the year 2030, and zero emissions by 2050. Also, the heating must be reduced to a minimum of 2%, at least 2%, but ideally 1.5%. If that is done, then there is a greater chance that the Earth would avoid the effects of dangerous climate change taking place. The court looked at the acceptance, global acceptance of that agreement, and Shell had endorsed, although it's not a party to that agreement between governments, but in its statements, even on its website, it says it endorses that target and also the goals of that agreement. The court now said, good. In that case, what we would impose as your obligation would be you must reduce your emissions in line with the Paris Agreement, which is 45% between now and 2030. You must reduce your global emissions by that figure. So that is the nature of the obligation that was imposed upon Shell. The court, in my judgment, did not act without careful consideration of, the evidence that was set before it, supplied by Milieaudefensie. And interestingly enough, a lot of the documents, especially when it comes to acceptance or endorsement of applicable UN Sustainable Development Goals and the UN recommended practice as it relates to human rights for companies, a lot of it was already endorsed by Shell. So the court found a ready excuse for applying that to Shell's obligation in this instance. So that's essentially what took place. And even though Shell has insisted that it would appeal the judgment, well, we just have to wait and see what happens to that. But essentially, that is what the court did. And the court said, if I may just refer briefly to the judgment of the court, it's at paragraph 441 and 442. I'll make a copy of the judgment available after this presentation. I'll email it through. It's in English. It says, RDS reduction obligation ensues from the unwritten standard of care laid down in Book 6, Section 102, that's the Dutch law, which means that acting in conflict with what is generally accepted according to our law is unlawful. That means if Shell has the obligation and is acting in any way that is contradictory to that obligation, then it is acting unlawfully. In this case, emissions without regulation. The interpretation of the unwritten standard of care calls for an assessment of all circumstances of the case in question. Then paragraph 442 goes further to say, in the interpretation, the court has included the policy setting position of RDS in the share group. That means the reason why it's imposing this obligation on Shell Netherlands, that's Royal Dutch Shell Netherlands, is because that entity has responsibility for setting the global climate policy and investment strategy of the whole of the Shell group. That's why it has done that. So making an order against that entity will be most effective in terms of combating climate change, harmful emissions and climate change. Then the court also considered the amount of emissions by the Shell group itself, which it says that the emissions are substantial on a global scale and exceed the emissions of many nations. That's just of the Shell group. The global emissions of carbon dioxide exceeds the emissions of many nations, including the Netherlands. So restricting them or regulating their emissions would be a proper remedy to grant. And then it also referred to the consequences of the CO2 emissions for Netherlands and Wadden region. Recall that the court was careful to limit its judgment, that's in terms of who it is dealing with. It was careful to limit it to the Netherlands because, as you would appreciate, a foreign court cannot decide what happens in another country where it is not sitting. It has no jurisdiction. But as I said, the impact of the judgment, the blowout, if we can call it that, of that judgment, it has global ramifications, and we will come to those soon. So the court also referred to the life, as I said some time back, referred to the life and respect for private and family life of Dutch citizens. And then it referred to the UN guiding principles. And the UN guiding principle essentially, it regulates how you ought to conduct your business to ensure you don't infringe or that you comply with human rights. Then the court also, of course, considered the influence of Shell over its business partners. Business partners, in this case, being those who supply products that it uses for its operations and those to whom it sells products. Then the court also considered what we'll call the emissions trading scheme in the EU. The emissions trading scheme, just by way of a small digression, is an arrangement where the governments in the EU have allocated a specific limit for each company involved in fossil fuel business. It has limited their emissions in such a way that you can only emit so much GHGs, that's greenhouse gas. If it gives you a target, if you exceed it, obviously you'll be in breach, and there are substantial penalties for that. If you use less, then whatever is left of your quota, you may sell it or you may store it. Some companies do sell. That's what you get with this carbon trading. And then it says, well, concerning this arrangement, it doesn't affect this order it has made on Shell, in the sense that if Shell's obligations that's the Shell's quota allowance for emission, if it's less under that agreement, and it is less, well, our higher target of 45% would prevail. So it is almost like between the devil and the deep blue sea. Either Shell accepts the court's emission target, or it would find no comfort from saying that it shouldn't be bound by the court's order because it has emissions allocations in place. That would be of no help in the circumstance. So the court took into account that fact of emissions targets being run in the EU. And finally, the court, of course, as I said, considered the issue of human rights, and that Shell has an obligation to respect human rights. Conclusion, and this is at paragraph, that's conclusion of the judgment, not of my presentation, please. Conclusion of the judgment, it's at paragraph 4455. 4455 of the judgment, and the court says, the court concludes that RDS is obliged to reduce the CO2 emissions of the Shell Group's activities by net 45% at end 2030, relative to 2019. What it really does in measuring emissions, you have to have a yardstick. So what it's saying is that Shell, you have to reduce your emission by 45%, but you have to use your 2019 emissions numbers or emission results as a basis for that reduction. Incidentally, in this case, in 2019, Shell had substantial emissions. So it has to use that as a basis for calculating the 45% target that was imposed on it by the court. So the court went on, through Shell's corporate policy, that means it's by devising its policies that it would be required to reduce that emission. And those policies made by the headquarters in the Netherlands passed down to all the subsidiary companies who are responsible for implementing those policies. Shell had sought to put forward the point that, look, you can't hold us responsible because, look, making policies just of themselves don't cause emission. Is the enforcement or the operations that bring about these emissions, and those things take place in various countries. But the court said no. Setting the policies is like setting the ball. Therefore, Shell Netherlands, being the policy setting entity for the whole group, must bear this burden and regulate the activities of its subsidiaries. That's in effect what the court is saying. This, I go back to the judgment. This reduction obligation relates to Shell Group's entire energy portfolio and to the aggregate volume of all emissions. That's the relationships I told you about in scope 1, 2, and 3. The reduction obligation is an obligation of result for the activities of Shell Group. This is a significant best effort obligation with respect to the business, with respect to the activities of the Shell Group. What this means is that for those emissions coming out of Shell's own mining operations, it has is compelled. It has a compulsive duty to reduce emissions to this 45% target. It has that. Then it goes on to say that in respect of group, that's scope 2 and 3, that's the emissions coming from Shell's suppliers and Shell's customers. The court says this is a significant best efforts obligation with respect to the business relations of the Shell Group, including end users, in which context Shell shall be expected to take the necessary steps to remove or prevent the serious risk ensuing from the CO2 emissions generated by them, and to use its influence to limit any lasting consequences as much as possible. What that really means is that because Shell determines who its suppliers are, and because it also determines what products it will be selling to third parties, because of that, it can have an influence, a substantial influence in persuading its suppliers and its customers not, or rather to reduce their carbon emissions in supplying these products to Shell and in using Shell's products. In fact, the court went further to say, look, if it came to it, Shell is able to determine by its policy that it would no longer offer some of the products that, you know, bring about a substantial emission of carbon monoxide. So it says, so Shell has that obligation and that influence, and it must use its best effort. It's not been compelled like in scope 1, because the court was aware that there are third parties involved who are not bound by this judgment per se, but the influence of Shell should be deployed, best efforts, to ensure that those emissions by these third parties or coming from these third parties' products and services must be brought within the 45% target. So that's essentially what the court did. I would now seek to look through what are the possible consequences. I'm trying to go from one slide to another, but it looked like we're temporarily, I'm not sure why. Anyway, I'll get the IT person to deal with it soon on this side. What it is here is that what are the possible consequences of, or should I say, the impact of this decision? What are the possible impacts of this decision? And what it is that Shell, although not a party, although Shell is not a party, what I would try and do, I would stop the share and try and put it back again because it seemed to be stuck. Sorry, I'm coming back. I'll put it back on again. Okay. Yeah. Aha. I'm relieved. So it comes to what are the possible impacts of this decision? How does this decision affect the fossil fuel industry, global climate change litigation, and global climate change policies? Well, for a start, this decision represents the first time that a court has held that a private fossil fuel company has a binding legal obligation to reduce its emissions as it relates to global emission. That's a big win for climate justice. So it's the first time that an energy company, and remember this is a global, an oil major, Shell, is the first time that a court has held them to reduce, to an obligation to reduce their global emission, so as to avoid the dangerous consequences of climate change resulting from those emissions. Then we also see that it's a judgment, yes, it's against Shell, but the impact is that other major operators in the fossil fuel industry are put on notice. And we would see from some of the subsequent cases that not much, but the new developments that have arisen, since Milieaudefensie. The impact is that other major fossil fuel companies are put on notice that they can be held to have what you would call corporate climate liability for their emissions. Another, I would say another aspect of this landmark judgment is that it's the first time that a company, that's a non-governmental company, has been held to have an obligation to reduce its emissions in line with the Paris Agreement. You recall, as I said earlier, the Paris Agreement is really an intergovernmental agreement that is between governments. The US, of course, has since rejoined the Paris Agreement, which the previous administration had withdrawn from. The rejoining took effect on the 19th of February, after the new administration had given notice that it seeks to rejoin the Paris Agreement. So one would not have thought that Shell, a non-governmental entity, would be held liable, but they were. And the court, of course, explained why it did that. Namely, Shell had endorsed this policy as one, that it acknowledges would be of assistance and with which it's ready to cooperate with. Also, the agreement represents international consensus on the issues of climate change and the need to reduce emissions level. Also, in that agreement, reference is made in the supporting documents. Reference is made to the fact that non-state actors must also do their part. So the court is saying, well, if that is what was said, and Shell says it endorses that agreement, then it must do its part by reducing emissions in line with that agreement. Then it's also the first time, this Milieaudefensie decision also represents the first time a court has extended this duty of care, legal duty of care, to a fossil fuel company by holding that harmful emissions are the cause of dangerous climate change, which endangers human life and the right to private family life. And companies have an obligation not to violate human rights obligations by eliminating or reducing harmful emissions. As we have said previously, the human rights angle was most critical in the court coming to a conclusion that Shell has an obligation to reduce emissions so as not to endanger human lives, because emissions, harmful emission into the air, into the atmosphere, causes or has an effect on dangerous climate change. And that dangerous climate change can result in loss of life and health issues. We would come towards the end of it to some examples like the recent flood in Belgium, when it comes to the effect, the harmful effect of global climate change. Then this is the first time that a court has deployed soft law, that is international treaties, guidelines, intergovernmental agreements, and reporting standards in finding a duty of care and a legal obligation to reduce harmful emissions in line with the Paris Agreement by a private non-state actor. Soft law, as we say, it's really international guidelines, international best practices Nothing really that Shell has signed on to as a party, but these were used by the court for determining, one, that there's international consensus that emission of carbon monoxide has an effect on climate change, dangerous climate change. Yes, it may not be agreements in which Shell is a party, but these were generally accepted scientific views that this was the cause of the activities that Shell and other fossil fuel companies were involved in. So this is the first time the court has used something outside the agreement of the party itself as a basis for finding that the party has an obligation to act in a certain way, in this case, to reduce harmful emission. Then, this is also the first time a fossil fuel company has been held to have legal obligations to reduce harmful emissions arising from its business relations with third parties using its energy products. As I said in the course of the presentation, Shell has two levels on which it interacts with third parties, which we refer to, because the judgment refers to as its business relations. Those who supply products to Shell, electricity, fuel, and other things it requires for its operations. Then the other level of business relations is those third parties that Shell sells its products to. So this is the first time that the court is seeking to regulate that relationship as it relates to emissions by getting Shell to say, no, you have to prevail on your suppliers that in their bringing these products to you, they must not go beyond the emission scope, which is 45% by 2030. And those you supply your products to, you must ensure that they too control their emissions. So this is the first time a court has done that, and that is quite far-reaching because, as you appreciate, especially in the common law legal system, which we all are part of, it's difficult unless you are a party to an agreement or that agreement is specifically made for your benefit. You cannot claim any rights or enforce any obligations on non-parties. That's those who are not signatories. But the court was able to cross that hurdle. In this case by saying Shell has an obligation and should use its influence to ensure, because it can control the list of suppliers. It can also control who is a supplier and how it approves its list of suppliers. It can also control the products it sells to its customers to ensure that those customers, it will tell them, look, we will not sell to you if your emissions level are not at a certain level. That's just an example. So those customers will be forced, of course, to improve their operations and reduce emissions. Then this is more of some concern raised by, some third parties, that there's also scope for some concern by third parties, such as financiers, insurance underwriters, and support services companies involved in supporting major fossil fuel company projects, that this extended duty of care to reduce harmful emissions and its implications for human rights may be applied to them. What this means is that if you are supplying finance for developing oil fields, then essentially you are contributing to harmful emissions of carbon monoxide. That's harmful greenhouse gases. It's not just carbon, there are other gases involved. But the effect is that you are facilitating the emission of harmful CO2 by financing projects or by providing insurance to cover that operation. Or if you are, let's say, supplying equipment, drilling equipment for carrying out these operations by these fossil fuel companies, then you may be exposed to liability under this extended obligation that Milieaudefensie has put in place. So that is a matter of concern for third parties who work, in the same fossil fuel industry, but facilitating major fossil fuel projects, such as the kind undertaken by Shell. So that's a concern for them. For environmentalists, of course, they would want to ensure that these third parties, financiers, insurance underwriters, support services companies, reduce their support for these fossil fuel projects. Then finally, and most importantly, in terms of the impact, the judgment, as I indicated, yes, it's a Dutch judgment applicable to the Netherlands, but what is important is that it represents a template or a precedent that can be adapted and used by courts in other jurisdictions to compel fossil fuel companies to reduce their harmful emissions from their operations and business relations with third parties. This appears to be happening now. I will look at some examples next. So essentially, what it is that the the parties, the judgment may not be a US judgment, may not be a West African judgment, but what it does, or what it has done, is that it gives a template to courts, either in the US, in the UK, Portugal, Germany, France, Guyana, Nigeria, Angola, Ghana. It gives them a template. Even in Australia and New Zealand, where there have been activities since the Milieaudefensie case, it gives them a template where they can make a finding to hold companies responsible for their emissions, adapting it to their local laws and local circumstances. So that is a major, major advantage, or should I say a plus, for climate change campaign activists who are committed to preventing dangerous climate change as we know it today. So, having said that, what we would look at next would be some of the other courts where there has been an impact. The first one we would look at would be a case from Australia. And the Australian case is quite interesting. It was decided, we'll just touch on them, we won't go into too much detail because these are foreign jurisdictions, not very close to our system as such. But the case is Sharma versus Minister of the Environment. It was decided one day after Milieaudefensie's case. There, the Minister of the Environment was in the process of approving a license, extending a mining license for mining of coal. And that extension would have brought about the emission of 100 metric tons of CO2 into the Earth's atmosphere. What the court now did in that case, the court developed or extended the common law duty of care to say the minister in question who would give the approval must take into account, it has a duty, a legal duty, to take into account, the care and well-being of Australian children, to protect them from the effects, from the harmful effects of climate change. He has to take that into account before giving any approval. Although the approval had not been given at the time the case went to court, but the court found a new responsibility by saying, no, climate change is important. The minister has to take that into account now before granting any extension of the license to mine coal. So that's one effect in Australia. Then there's the German case, Luya and RWE. It's against the German government. Essentially, what it says, of course, coming again, these are developments that are touching upon what we have seen in Milieaudefensie. In this case, the German government was taken to court, and the people's claim was that, look, the laws, the climate change laws we have put in place, they have stipulated, yes, that people must fossil fuel companies must reduce, in Germany, fossil fuel companies must reduce their emissions by so much, 55%, up to, by 55% up to, just a second, please. They must reduce their emissions by 55% up to the period 2030. But the government has not made any laws to protect our right to life by reason of harmful emissions. The government has not made any laws about regulating emissions after 2030. So the court said, yes, the government is acting unlawfully and it is in breach of its obligation to protect the lives and property of the people, because by failing to make that law to limit emissions up to 2050, in line, of course, with the Paris Agreement, then it means after 2030, the people will be exposed to unregulated emissions. So that's what the German court said. And the German government, I gather, is taking steps to extend the emissions targets for fossil fuel companies to 2050, in line with the Paris Agreement. Then one further case we would look at, just a second, is the case of the Portugal case. It's called Augustino, and the government of Portugal, not just the government of Portugal alone, but it has several other governments of the EU that have been asked or that have been sued. And it's a case brought by Portuguese children. They are saying, or their claim is that their governments have failed to take actions over climate change, and that failure has adverse effects on their right to life, which is Article 2, right to private family life, which is Article 7, and the right to be free from discrimination as it relates to applying these two rights. That means, why should children's lives not be protected under Article 2 and 4, under Article 2 and 8? So it's saying failure to do that means you are discriminating against us in how you apply these human rights provisions. That case hasn't been decided yet, but the European Court of Human Rights, which will sit on it, which will hear the case, has fast-tracked the proceedings so that it has requested for the relevant governments to file their defense statements immediately or within a very limited time so it can determine that case. So that would also be another interesting one to look up to. Then we would now come to penultimate issue, the US perspective. All the while we've been speaking about foreign clients. How does this relate to the US? Well, it's interesting, but the Supreme Court case of Massachusetts and the Energy Protection Agency, it's a 2007 case decided by the Supreme Court. But the nature of the arguments there are eerily similar to Milieaudefensie's arguments in his case. So just as Milieaudefensie was saying, Shell, you have an obligation not to emit harmful harmful carbon monoxide, which affects climate change. Here, the parties were saying, look, the EPA has an obligation to make rules that would regulate carbon monoxide discharge into the air under the Clean Air Act, of course. And that in failing to do so, it was violating their rights, their due process right to life, and also the consequence of that would include increased sea levels, which was affecting the state of Massachusetts. Well, the Supreme Court, commending them, agreed and said, yes, they accepted the effects of global climate change, and they ruled that, yes, the EPA has to consider the issue of making or not to make rules regarding carbon monoxide emissions for new vehicles that were to be produced in the US. So in that instance, it was clear, the Supreme Court made it clear that, look, there is a connection between these emissions and global climate change. And therefore, the EPA has the responsibility to make the rule that would regulate it, or they might as well give the reason why they would not make the rule. That was essentially what it was about. And that would have been a blistering, shall I say, that would have been quite a stunning improvement in terms of global climate change litigation in the US. But there was a caveat that the court put in there, which, more like a damper on what would have been, a record-breaking breakthrough in climate change litigation. The court said, look, yes, we have reached this decision today, but it is of considerable importance that one of the parties in this case is a state, a sovereign, that's Massachusetts, and it has a long coastline which is adversely affected by climate change. And that, it's more like the reason why we are letting this one through. So again, it's like the Supreme Court gave with one hand and then took away with the other hand. because it referred to its earlier decision of, I didn't list it here, but the earlier decision of Lujan and defenders of wildlife. In that case, the court declined the case on global climate change because it said the plaintiff, the claimants, they had no standing because they couldn't show harm, direct harm coming from climate change to themselves individually. And so it's on standing grounds, it refused that case. But here the court made an exception, but that exception was because it said Massachusetts was a state. So the question is, what happens if a state is not a party? Does it mean that we will be tied back to the Lujan decision, which of course says you would have no standing because you can't show, for example, in practical terms, that it was the emissions of Shell's operations, let's say in Iraq or Iraq, that was responsible for your heart condition in New York. You can't show it, direct link, you can't. So that's the difficulty with that case. Then the second case was a spirited effort, I must say. It's Juliana against the US. It's a case by 21 children and other environmental activist groups against the US government. It was during the last administration. They were alleging that their right to constitutional due process, in terms of having a proper climate system that will not undermine their health and their life, that their right to it was being interfered with, or was not being upheld by the state, that's the US, because the US was still involved in subsidizing fossil fuel operations and the use of fossil fuel, and have not put in place any law to regulate or compare regulation of harmful emissions, and that these violated their due process rights, constitutional due process rights. Well, the Ninth Circuit in Oregon, they were sympathetic to the plaintiffs. They said, yes, we agree. Harmful CO2 emissions has an effect in bringing about dangerous climate change. No question about that. We agree with you. As to whether you have standing, well, you have standing because you have shown that, yes, this person suffers from asthma, this person suffers from this ailment. So naturally, any change in the environment due to dangerous climate change, global climate change, is going to affect you. It will affect your breathing because the air deteriorates, the water becomes less pure. So you would, and of course the adverse weather too, the fires of California and the flooding of Galveston in Texas and other places where this has occurred. Yes, rising sea levels, yes. Food shortage, yes. But, and that was a most painful but for the plaintiffs, but this type of case is not one that a court can grant you relief. Because if we do, it simply means that we will be stepping into the shoes of the political arms of government. That's what the court said. And then in so saying, it invariably meant that the court will do nothing for them. In that case, that's Juliana's case. Kindly permit me just to read what the court specifically stated. It says, at page 175, I'll make it available. The plaintiffs have made a compelling case that action is needed. This is the Supreme Court speaking. It will be increasingly difficult in light of that record for the public branches to deny that climate change is occurring, that the government has had a role in causing it, and that our elected officials have a moral responsibility to seek solutions. We do not dispute that the broad judicial relief the plaintiffs seek could well goad the political branches into action. We reluctantly conclude, however, this is where the but came, that the plaintiff's case must be made to the political branches or to the electorate at large, the latter of which can change the composition of the political branches through the ballot box. That the other branches may have abdicated their responsibilities to remediate the problem does not confer on Article 3 courts, that's federal courts, no matter how well-intentioned, the ability to step into their shoes. So this, in effect, was what the Ninth Circuit said in declining to enforce the rights of these 21 children when they sought to bring an action to prevent harmful emissions resulting from government funding or subsidies to fossil fuel companies. The other aspect, more on the positive side, is President Biden's executive order 1408 of January 27th, 2021. In that order, the president clearly indicated his policy goals that he'll be driving very hard the climate change agenda, which is to ensure that we have renewable, clean sources of energy, that there be a substantial reduction of fossil fuel energy. And also, the president has also identified the fact that global climate change must be tackled at a global level. And that is where the solution probably lies. Because if you look at it, from my little investigations, or should I say research, these companies, if you make an order against them, in some instance, all they do is what we normally would call brown washing. They just sell the assets to another company, in which case they no longer have responsibility for it. But the company they've sold it to would carry on business as usual. So it's almost like an unending life. So the best of efforts would be at an international, intergovernmental level. The Paris Agreement, as I indicated earlier, is an intergovernmental document. It requires each signatory to supply every 5 years what they call nationally determined contribution, which is what will your country do for the next 5 years to reduce emissions. And you have to bring up a new plan every 5 years. And the plan for any subsequent 5 years will be more effective, more poignant, more aggressive than the previous year, the previous 5 years. So in my judgment, that is a good starting point in dealing with the issue of global climate change. Finally, we can just look at some of the pictures. This there was recently flooding in Germany and in Belgium less than 2 weeks ago, and it was catastrophic. About 200 people, 190 or 200 people lost their lives in the process. I think the lives of those people should not be lost in vain. The least that could be done is for all parties at all levels should do their utmost to stop the dangerous effect of climate change. It's a poignant reminder that the time for debating whether climate change is real or not is long gone. What is required now, as rightly captured by President Biden's Executive Order 1408, is to take radical steps at all levels to avoid this and to preserve the earth for those who would come after us. So this is the picture. This is just a picture of the debris resulting from that flooding. And then this is one of the towns in Germany, all sunken in flood. Well, if there was any doubt about climate change, certainly these pictures have put an end to it. This inside a departmental store affected by the flood. You can see the watermark. And this is a cemetery, burial ground. The flood waters did not even spare the dead. And you can see even cars were swept into these places. So thank you very much. And thank you to the Omni Center for having me. I'll be happy to take any questions as appropriate relating to this topic. Thank you. Thank you.
That's really amazing, Teraine. Thank you.
Thank you.
Teraine, I am so happy we have that recorded. May we, and I'm sorry we have so few here today. That has been such an incredibly valuable presentation. May we show that at other places to larger gatherings? Do we have your permission to do that?
Yes, by all means, please.
Yes.
Yes.
My question is, this is so amazing that this has been done by a court. And I'm wondering, you say that other actors will be impacted by this because of a precedent by the court having this effect. I'm wondering if how what I guess I'm well one Shell is appealing.
Yes.
Two, what mechanisms are there to enforce this decision, and three, what mechanisms might be actually available to courts if they even do have this template or this precedence to act in other countries, such as in the United States?
Well, what it is, two things. Firstly, the effect is that's in terms of the legally binding nature of the judgment. It's limited to the Netherlands. That's the legally binding. That's in terms of the court being able to enforce the judgment. It's limited to the Netherlands. But the effect of that policy, of the judgment, is that Royal Dutch Shell, you are responsible for setting emissions targets and policies for all your subsidiaries in every country in the world. If you have that responsibility, and you do have it, then we are compelling you that the policies you make must be such as to bring all these shell subsidiaries all over the world into compliance. So it's almost like holding a parent responsible for the sins of the children.
And so you couldn't separate Exxon and BP?
No. No. For Exxon and other fossil fuel companies, the judgment does not bind them at all. Only, of course, if they have business dealings. For example, if they supply a fuel to Shell for some operations, or they buy things from Shell. In that case, the court says, through Shell's policy setting, it must ensure that the supplier, that's, let's say, Mobil, the supplier or the buyer of Shell's products must or should reduce its emissions to this level.
But on the other hand, there were a couple of, several fossil fuel companies have had those shareholder revolts, where the shareholders are actually saying, you guys need to be doing something about emissions, about our company emissions. And, this is more pressure on them.
That is it. In terms of the enforcement of this, or rather the relevance of this decision and the impact of these decisions on other fossil fuel companies, let's say Mobil, Exxon, and the rest, Total, Elf, the effect, and Ajib, the effect is that their shareholders are now aware and also looking at what is going on in the EU and in Australia and in New Zealand. Their shareholders are now aware that, we could be held responsible because a party can sue. Because we also have those companies present in the Netherlands, but a party can sue and seek to enforce these kind of obligations on us. Okay. No shareholder or investor would really love to be exposed to that kind of risk.
Right.
So if that be the case, it's more like it would have a bearing in terms of how they would invest, and also it will have a bearing when the oil companies, the other oil companies unaffected, when they come together to create their policies, especially policies on emissions. Yes, the judgment doesn't touch and concern them, but they would certainly take this judgment into account in formulating their policies. And what many of them have done now is that they've spoken extensively to their attorneys, they've spoken extensively to their board of directors and the executives, saying, look, how does this judgment, looking at this judgment, how best can we review our operations so that we are not found to have fallen foul of these international conventions as has happened to Shell? It's more like people are learning from Shell's experience. So it's that pressure that has come about. And I'm also sure that in a number of countries, litigation is being contemplated along the lines of Milieaudefensie against fossil fuel companies operating in those regions. So that is the impact or the effects on those who are not necessarily parties to this Milieaudefensie case. Thank you.
And then Teraine, there's also a question from Marlene in the chat I'm going to read for. The question is, how is the serious issue of the need to clean up the environment, environmental devastation reached globally by Shell, with the Nigerian Delta being a major case? Of this, if this question of environmental remediation, restoration, as well as environmental justice has been addressed, please excuse me, but it hasn't yet, but how does it relate to Nigeria?
What I would say is that they are still a way behind in those parts, not just the Nigerian state, but many of the developing petrostate nations. They are still a bit behind in terms of really taking on board the issue of climate change and remediation efforts. Yes, in Nigeria, there were attempts, for example, with the Ogoni spill in the Niger Delta region, there were attempts, or should I say, there were statements made about facilitating the cleanup of those environmental sites where there has been considerable damage. In many of these places, in fairness, the environmental damage costs are irreversible because many of them took place, for quite some time and nobody did anything about it. I have no doubt that if the governments in those areas had put relevant regulatory measures in place, perhaps things may have been better, but they didn't do those. And that's why they are still a little bit away. But at the end of the day, they cannot be allowed to, as it were, live a life of their own when it comes to remediation. So part of the litigation, yes, there's been a lot of litigation cases in the Niger Delta, but none has really touched upon global climate change. In fact, the global climate change science, many are not even aware of what the issues are. Yes, in the environment, oh yes, we see these plants have been damaged. Yes, we see our water polluted. But in terms of how it works on a global scale, they're not aware yet. But litigation is being brought or is contemplated to bring them up to speed in terms of regulatory efforts. The other angle I see on the Nigerian side is that when they were giving out many of these oil mining leases, nobody thought about decommissioning or remediation. They were just giving them out. They didn't make provision to say, okay, whenever you finish your operations, you must have a specific fund available to do cleanup. They only say, yes, you do cleanup. That's the 1969 regulations, 1969, I hasten to add again. Regulations say, yes, you could do cleanup. But it doesn't go for that to say, oh, you must set aside so funds like the one in the UK, where you must set aside certain amount of funds or insurance indemnity to carry out cleanup works. But that was not there. So they still have a way to go. But as it is said, the journey of 1,000 miles starts with one step. So litigation in the line of Milieaudefensie is likely to be commenced in those areas, not necessarily to make life difficult, but to sensitize the authorities on the importance to undertake, policies and put in place measures that would reduce harmful emissions and turn itself into more cleaner forms of energy. I know that the Nigerian government, for example, has put forward, is a signatory to the Paris Climate Agreement. It has put forward some plans that it says it has to remediate, or rather, change its energy dependency on fossil fuel to renewable energy. And part of it includes planting of trees and then putting more solar energy in place rather than not the present fossil fuel power plants that they have. But they also confirmed that they would need funding to effect these changes. One step at a time, I would say. One step at a time. So we will see. They need to come up steam. They need to come up to steam. They are still a bit way back. Policies would certainly be put in place, or rather, we will take steps to ensure that at least there's some sensitization to ensure some policies are put in place. On the cleanup, as I said, they have promised, the Nigerian government have promised, they said funds will be made available for the cleanup. I know in particular relating to the Ogoni area that there will be cleanup exercise going on there. But we wait in hope. That is where we are. Thank you.
Well, then I had a question about the way that Shell might go about attacking it when they respond. And I'd thought of a couple of ways, a couple of things that you said that sounded like they could be ways that Shell would be, you know, trying to make inroads. And I was thinking mostly about that decision about where where they were talking about business, you know, that could they really be held responsible for what then their customers did. And then there was another one that was about the Julian case, about could they questions about the political.
Oh, political, yes, political questions. Yes, what I would say is, firstly, you know, this Milieaudefensie judgment, it didn't just come out of the blue. There was a case, a Dutch case before it. It's the same district court that decided that case. It's agenda against the government of the Netherlands. In that case, this same set of judges found that the Netherlands government had an obligation to tackle climate change because it had a corresponding obligation to protect the human rights of its citizens, namely right to life, because of the effects of climate change. So in terms of how they might attack this judgment, reading it in my best thoughts, you see, there are many things that happen, and it's not just a question of law. It's a question of tackling a problem, albeit with small steps. So yes, there are spaces in there. For example, Shell may argue that, look, these international treaties were not parties to them. They were never binding on us. So why would you hold us to that level of responsibility? Yeah. But I look on the other hand, the effect of climate change is there for all to see. We cannot deny the science about the effects of global warming is there. So the judges too, and you would appreciate too that our laws are never static. Law, that's, I mean, in terms of the actions of the court, its decisions and its interpretation of the law is not static. It responds to what is happening in society. So on a legal side, yes, Shell may have some good grounds there for maneuver to overturn the decision, but the effect of climate change is there. The risk to the Dutch citizen is there. And this is not just because they said it's there. The science, the best available science, which informed the Paris Climate Agreement, is also there. They themselves, as I said, had endorsed that, yes, climate change is taking place. And not only that, their own policies on climate change were very much in alliance with what the Paris Agreement said. What was their difficulty was that when you look at the investment strategies, they did not line up with what the climate change strategy says. And that's where the court, you know, really tied it in and said, no. You said this, but you are doing this. You said, yes, you've been carrying out studies for many years. So you are aware that fossil fuel is harmful or emits harmful carbon monoxide, which affects people. You are aware of that, there's no question. Yes, you said it in your report, yes. So why would you not want it to be regulated? So these are the difficulties I see. On a legal side, yes, they have many grounds they could pull out, but in terms of the practicality and really judgments of courts deals with practicality, people's lives. In terms of that, it may be a struggle to overturn the judgment, but you know, never say never, because the previous case on which this case stood upon, which is the Grenda one, the one against the Dutch government, it was fought, you know, almost on the same terms. Saying, no, it's a political issue, it's a political issue. But the court said, no, it affects people's lives now. It's a human rights issue. And it went all the way to the Netherlands Supreme Court, who affirmed it. So I would say, in terms of overturning the judgment, well, we just have to wait and see what the court will say. But hand on heart, if I can say that, it may be difficult. It may be difficult. What some of the companies sometimes would probably do is divest themselves of some of these troublesome assets, which I understand Shell has done some divestment in Nigeria. In fact, shortly before this Milieaudefensie judgment was issued, they did that. Wow. The question is, who did they divest it to?
Dang. Well, that does bring up another question to me then. Might they, is there some way that they can like move this case to a more friendly court to them?
No, because
no. Okay.
No, they can't. No, because you know the Dutch system is quite regimented, based on the Napoleonic Code, you know, which they have. Once it goes to this court, the next court is the Court of Appeal.
Okay.
You can't shift it anywhere. And not only that, as I said, why I said it may be challenging, because look, the first case, which was even against a more powerful force, the government of the state, or the government of the Netherlands, this same court sat and gave that judgment, saying, no, you have obligations to make laws to reduce these carbon emissions. If they did that, and then the Court of Appeal affirmed what that court held, that they agreed with them, and the Supreme Court agreed with them, and that was just in 2019, it would be difficult now to see a somersault in the policies. That's my view. That's my view.
I would like to, Alberto has a question. Alberto, would you like to mention your question or your comment?
Oops, I think we lost Alberto. Maybe can you read the question, Shelley?
Well, he says, this reminds me of the efforts to provide nature with rights, but also enterprises enjoy to Ecuador, Bolivia, and New Zealand are examples of such. Some suits have not been upheld, but as precedents going back to early 2000s have stimulated more efforts in a much complex framework of the law. I think there's a chance that Shell's appeal may succeed by arguing they are being treated unfairly for being the sole and only entity in this business being held accountable, but it is at the very least a great precedent.
Yes, that's a very good question, because there are a lot of activities in Ecuador and Latin America when it comes to fossil fuel company. But you see, the issue is human rights. The counsel who framed the arguments made heavy weather of human rights and the fact that Shell had endorsed virtually all the policies in question. The other aspect of it when it comes to many of these things is that it would require, I wouldn't say a brave judge, but a strong judicial institution to pull through many of these things. So for example, in many of the developing nations, the judicial institution is not as strong and established as what you might find in terms of the Dutch court system or the Dutch judicial institution. So many of the other developing nations, the judiciary is not as independent as we would have liked it to be. So in those cases, you may have a lot of political influence or pressure. But in the Dutch example, it was not, the courts were not under that kind of pressure. And what actually happened is that these same arguments were made by Shell. For example, that look, global emissions has multiple actors taking place all over the world. We cannot be held responsible for global emissions because there are many actors.
Right.
But the court said, look, you have to respect human rights. I agree with you that global emissions is caused by multiple actors. There's no question about that. But your own proportion of emissions globally exceeds that of this country, Netherlands. And restricting you in this manner would certainly contribute, or rather, it would enable you make your own contributions towards reducing the effects of dangerous climate change. So the court was careful in couching the responsibility, they call it the obligations. It was careful in couching the obligations it placed on Shell. A lot of the documents it relied on, hardly any were not endorsed by Shell. A lot of them were endorsed by Shell. And the issue of climate change had come before that same court before. So in my own judgment, yes, in the developing nations, I could see why, for example, cases like Milieaudefensie may not have scaled through. But in the Dutch system and the independence, the level of independence of its judicial institutions and the development of those judicial institutions was such that the judges were able to issue this order, onerous as it is, but they weighed it against human rights, life of the Dutch people, the science available, the dangers from these activities, Shell's own confirmation that yes, these climate change issues require attention. That's what it is. So yes, in the developing nations, yes, it's possible we may not have a strong enough judicial institution or an institution that is independent enough as we would like. But at the same time, on this one, Shell's claim of not being solely responsible, the court rejected it and said, well, your emissions are high on a global scale, it would make an impact. And you should at least make an effort towards global climate change. For that reason, we will find that there's an obligation.
If we may impose on you just a little longer.
No problem.
There are some people who haven't had a chance to ask any questions. Are there any burning questions out there? We're at the end of our time, but I am really loath to let this amount of knowledge go so quickly. So is there anyone who hasn't asked anything?
I would like to make a remark because my heart is so filled with what has just happened. I have never seen a court case like this with companies being held responsible for bad things that they've done. And based on the right to live and the right to family life. I mean, that's the whole thing right there. That is the whole thing. And I think that's why, you know, a lot of court cases don't get won in the United States because they don't put enough price on human life here. You know, I mean, like hundreds of thousands of people can die from a anomaly in a car engine or something like that before they'll do anything about it.
Yeah.
You know, but just the fact that they have, number one, acknowledged that we have a right to a clean environment and a healthy environment. We have a right to live a healthy life. That to me is just so big.
It is, Lolly,
Thank
Really
you.
appreciate this.
It's all right. It's true. You see, I recall in one part of the judgment where Royal Dutch Shell had stated to the court that, look, this judgment or these obligations you're putting on us is going to have a far-reaching effect in terms of, you know, our commercial interest and the others. The court said, look, human life exceeds commercial interests. So we have to choose, do we leave or do we go with the commercial things? There has to be some movement for the benefit of everyone, not just us against them. No, for the benefit of everyone. I think that's what it is.
Lolly.
Lolly, you're muted.
Thank you.
My impression of the Netherlands is they're a much more progressive country than the United States. And I think what Valley has just said is the essence of why they are. Does that seem to be to you the truth, Teraine, that the Netherlands are more progressive than we are? We're so caught up in neoliberal capitalism and growth at any cost, with greed being our primary goal. Well,
what I would say is the Netherlands have been, they're quite advanced in many things, not just oil and gas. You understand? They have certain policies on many things that, you know, you and I may not necessarily subscribe to. But again, I feel that the new administration of President Biden, looking at his Executive Order 1408, we've never had anything like that. It provides a very good opportunity for us to make progress in that respect in the US. And we may not have started as earlier as we would have wanted, but there's nothing wrong in starting now in terms of ensuring that we turn to cleaner forms of energy as much as we can. Yes, there may be technical challenges, but to fail to start is to begin to fail. And what, for example, New York has done is that they have laid down their policy, you know, for cleaner forms of energy. The Governor Cuomo, earlier in the year had announced the award of major contracts to Equinor, as the Norwegian oil giants, and to BP to build wind turbines off the coast of New York, which will supply substantial energy, wind energy for electricity generation. And not only that, once that comes on steam, then some of the polluting plants in New York would have to be decommissioned. So it will take some time because, as you know, the state, the nation is quite substantial in terms of energy. So what it would be, in my judgment, is a collaborative effort. We may not have started as earlier as we would have wanted, but President Biden offers a new and substantial opportunity to make considerable progress in terms of our energy transition. We consume more energy than, of course, the Netherlands. So we would, I'm sure we would get there, but President Biden's policies, we have to go with them on this issue of developing cleaner forms of energy. I commend those. Thank you.
Shelley, you're muted again.
just that we're past time, and we're so grateful. And Teraine, I hope we can maintain touch with you, because I have 100 more questions, but I don't want to impose them on you now. But I may be emailing you.
Email them to me. I'll deal with it. Anybody who has any question can pass them through, the Omni Center.
Okay.
I'll happily deal with them.
Okay. Thank you. So
Thank you.
Yes, we are so pleased and so happy for all this incredible information.
Yeah.
Whew.
Thank you very much.
And thank you to everybody else for sticking out to the very end. That was wonderful. And we'll be figuring out how to share this video as soon as we've got it in a place we can actually share it.
I will send through the judgment in English, Milieaudefensie.
Oh, thank you.
So
Thank
you
you.
have it for your records in case you want to refer to it, if you want it, obviously. And I
Thank
think
you.
that
Appreciate it. And Teraine, I really do think that you presented this in such a very clear and succinct way that really helped us assimilate a huge amount of very complicated information. And I really do thank you for that, for the way you organized this.
Thank you. Thank you very much. And thank you to the Omni Center. I'm grateful.
Thank you. Okay, everybody.
Thank you. Bye.
Thanks again, and bye-bye.
Bye.
Thank you. Bye.